Ajabo eja enya ababedu menewo kasa yi de judge a ono etimi etena ejem Justice Audrey Kusivi Tei eyade se watimi de ne ruling aba na sede kan no initially no chairman Wontumi lawyers etimi de application ekokopie mu ho senka court no entimi entwentwan ne na ase kakra nenka won enkonkopie mu Supreme Court Emra nanso Justice Audrey Kusivi Tei a ono etena adwam no enya ade se otimi agitum mu na wanya ntum no oto aso se obetimi de ne judgment etimi de ababo to abonten ema obia hu inti count ahodo ayede bo chairman Wontumi no eya ade se ebi wo ho a odi fo ene bi nso wo ho a wandi fo na tie otimi edi efo no eno ena court no etimi ede hu judgment aba a judgment no enye asem kotoa na judgment no a eba beto dwa no ama court dem aye butu a eno enye asem kotoa na me na waka say de judge no etimi a sentence chairman Wontumi 20 years in prison after saying lawyers etimi ebo modern judge no ekasa say oh chairman Wontumi ewogere ewo ma wo Ghana ha ena afa baabi a court no ebehwehwe ni bia obehu no entimpo se nka court no ma na judgment a ontimi engogo nioma mu kakra entimi emfa ema chairman Wontumi nanso Justice Audrey Kusivi Tei etimi enti asem no emwo rule se chairman Wontumi enkononkonko pie mu 20 years ewo efiase ena afa osan fine no fine no die ebubo no te se count 1 no otimi fine no 180,000 Ghana cedis a utimi de call titisika no ma 1.8 billion and was a chairman Wontumi etimi etua now there yemko some of the videos ewa bra chairman Wontumi and a lawyer for etimi appear free court and na enye asem kotwa.
And in fact, he initially prayed for more time for him to familiarize himself with the case. The proceedings that went on before he took over this particular case. The court granted him that particular time, and that Atacha was well aware that the court was going to deliver this judgment. He should have told the court that he wouldn't be around today, but he never did that. And in fact, according to Audrey Kokovise, an experienced lawyer judge here at the High Court, she said if Atacha had told the court that he wouldn't be around today, then the consultations would have gone on, and in order to set an appropriate day for this particular judgment to happen, but he never did that. So it was incompetent. It was smooth. Lawyers or for Atacha to even write to the court and tell the court that he wouldn't be around today. So the judge simply dismissed that particular letter as well, and then went on to read the judgment. It took more than an hour basically reading this particular motion, and when she read the motion, the judgment point, she clearly said that based on the evidence adduced by the prosecution, Chairman Wontumi was found guilty in the charges that were slapped against him. And the prosecution called 4 witnesses. The defense, that's Wontumi's lawyers themselves, also called 5 witnesses, including Chairman Wontumi himself today, and the judge basically said that the prosecution was able to adduce sufficient evidence that meant that Chairman Wontumi would be convicted. When she was done reading the judgment, basically, so when she was done reading the judgment, the counsel in court today, who was holding the brief of Samuel Atacha, Charles Boachi, was on his feet, and he sought litigation. He sought to mitigate the process, in order for the court to reduce the number of years that Wontumi would get at this particular point. He did that. He was so nervous whilst trying to plead the court to reduce the number of years. His hands were shaky in that particular process. He did that after a few minutes, and then another person who also rose on his feet, he also mentioned the fact that he wanted to, explain to the court that Chairman Wontumi has a lot of businesses, and for that reason, if Chairman Wontumi is eventually, sentenced to so many years, that could affect all of that. But let's listen to one of the lawyers who was in court today, just to appreciate what he makes of this particular process.
We are around that. Because yes, I do appreciate that, yes, there are situations where the veil of incorporation could be lifted and directors could be held responsible. It is not in all situations that those things are applicable. So I'm sure it's an area his lawyers would have to look at and see if it will open up some areas of appeal for him. But I'm a bit worried and a bit sad.
An offense that the minimum is 15, maximum 25. The judge, I think, might have listened to your plea, don't you believe?
Probably she did, probably she did not. Because I was of the view that the minimum sentence was okay. Because I made a point that getting Wontumi out of the picture, that is incarcerating him, may affect a lot of minimum of sentence. That was what I did. I don't
argument that it should be as a deterrent sentence to persons despite the fight against illegal
considering
mining.
the way
you see, I am not in any way encouraging anybody to go into illegal mining. And for me, the point I was making is that yes, Mr. Wontumi may have committed the offense, but it was the bigger picture I was looking at, because he was going to be sentenced anyway. So my mitigation was to reduce the sentence. That's all. It's not to put in a defense for whatever he might have done or not. Exactly.
What is your relationship with Wontumi?
I thought he would have been given the barest minimum.
What is your relationship?
I don't know him from anywhere. Probably we just share a name. I'm Bernard. He's Bernard. I have no relationship with Mr. Wontumi. Maybe because he's my namesake. But I only felt that as a lawyer, these things happen. It's not because it's Mr. Wontumi. There are times when you are in court and you feel like you need to probably intervene as a friend of the court. It is something we do out of ordinary practice. It is not because it was Mr. Wontumi. We have done this several times where we believe that we need to add our voice in mitigation. Remember, it is not against the conviction. It was just to intervene with the number of years he was going to be given. So it was against the sentencing that we were trying to mitigate, that the court should give him the barest minimum. It was not against his conviction. So it is not as if I did that to probably encourage illegal mining. No. It was just for the courts to understand that Mr. Wontumi is just not like you and myself. He owns a lot of businesses. So the court, I don't know if she consideed that, but well, I'm sure his lawyers would advise him accordingly.
So that's
allow me to go.
Bernard Oredu.
Bernard Oredu there talking to the press at the Accra High Court. Basically, he was one of the lawyers who was on his feet in criminal court and in fact, in his arguments in court, he told the judge that Wontumi has so many businesses and that if his sentence, if the years are too many, that could cripple some of the businesses, and many of the people who are currently employed by Chairman Wontumi's companies may lose their jobs, among other things. But the judge, in her, concluding part of the judgment, said that this is to serve as a deterrent to other people who are currently, involved in illegal mining, and went ahead to give Wontumi, or to sentence Wontumi for 20 years. But it was very interesting, Mami, in court today. In fact, Wontumi himself, in the process of the judgment, whilst Audrey Kokovite was reading the judgment, so he was clearly, shaking his head repeatedly in apparent disapproval of some of the things that the judge was talking about, and he was also consistently looking at the people who were sitting in court and basically, laughing and all of that. So at the moment, it is clear that the court has now made its determination in this particular matter. And in fact, some of the interesting things that have happened in relation to this particular trial is that
enti abusia for videos no na hu say etwagu no na kire say court dem atimi aye butu a eno enye asem kotoa chairman Wontumi ejebo judgment no ababedu a chairman Wontumi ekwa serve 20 years in jail after say judge no kra etimi ede judgment no eba beba no Wontumi a lawyer for etimi epa ne chew say Wontumi wo yere ewo ma esa wo business bebre ho asa wo de no kra kopie mu ewo afiase mfie pia adeɛ sɛ ebetimi aha chairman Wontumi ɛna afei na busuafo ntinka court ne kra nhwɛ ne nka jail term ne kra nka onya ho bibi kakra nanso judge no etimi ebu nua egu na sum a me na o kasa deɛ ɔde chairman Wontumi ɛkɔ akopie mu ɛwɔ afiase for 20 years na Wontumi a lawyer for ne bi nso kasa adeɛ nko
case, and they are coming out and taking the leave from the court premises. So the conversation will largely be on social media and reliant on outlets like ours to inform them. Now, the difficulty or the only thing we should be worried about with that social media conversation would be the likely misinformation that this would generate. And that is why we have to be timely also with our broadcast, so that people do not get misinformed in their efforts to follow the live feeds and to understand what really is happening in real time. The social media conversation is such a way that you would often have people who jump onto it. They jump onto it from all sides. They probably don't even understand what exactly it is. You just mentioned count 4. What does that mean to the ordinary social media person who is following the conversation? May not understand, but will jump onto it and try to interpret for his or her followers. That is where the real danger is. Again, as to whether the party members are massing up elsewhere, maybe there's some communication to them to meet somewhere else, maybe at the party office, that we do not have information. But within the immediate precincts of the court complex, we don't have such people gathering. We don't have them. And as I said, even the security detail here is not so heavy. That probably is because intelligence would have suggested that we don't anticipate any massing up of people, any unnecessary commotion and all of that. People are following, yes, largely from social media, largely from our own outlets. And we'll just encourage all those who are following to follow us also on our social media platforms for detailed, accurate and fair reportage on what is happening here at the High Court complex.
And just to also bring up to speed what we're also monitoring from the courtroom as this judgment is being given, we also know that referrals have been made to IDs that are said to have been not only misplaced, but more importantly, seem to have been faked as well in relation to the interested persons in the matter, as well as related to the directors of the company as part of those accused in this case as well. And then moving on to the subsequent issues, it also means that the interested parties would have to also be aware, all interested individuals for this matter will have to be. This is what we're going to do. We're going to make sure that for all those interested stakeholders and politically exposed persons, either close to the accused persons or the company or the entity as part of those accused in this case, we'll make sure that related to this coverage, we also are able to touch base with them. And rightfully, we have to make sure that we go to the base of the Ashanti region, where we know that Chairman Wontumi, Bernard Nkribo-Esiakun, aka Chairman 1, is also the chair for the MPP for that region. We'll take you to our lead reporter, the one in charge of our bureau for the middle half of our country, Evans Inkum, to give us the latest. But Sixtus, when such a coverage is being given, it also means that we have to stay onto the facts of the case. And then for those individuals either connected to
the punishment was made stiffer, because around 2019 was when illegal mining was just causing a lot of problems. And so there was such an agreement that the punishment that were offered in the original act were not punitive enough. And that is why the law was amended in 2019 to make room for much more stiffer punishment. And so we'll get to know pretty shortly.
I'm learning that the maximum sentence is actually 25 years.
25
the minimum is 15 years. And we're also learning that counsel for Chairman Wontumi is urging the court to temper justice with mercy, because Chairman Wontumi has shown genuine remorse and has also cooperated fully throughout the trial and is a devoted family man, and that the defense accordingly prays for the imposition of maximum sentence, because you can understand the two sides.
But this is not showing, right? So
yeah.
this is Chairman Wontumi, who has maintained his innocence throughout the trial, and actually says that I did not commit the offense. And now these are the lawyers who are telling the judge
tables have turned now.
He is now shown
remorse.
Where is the remorse when you say that you are not guilty? And so I get that. I'm not saying this against Chairman Wontumi.
We're not in the courtroom.
I'm just saying that if you are innocent and you did not do this and you maintain that, remorse means that you accept that you did something wrong, but you are saying that I admit that I didn't do well and I'll do better the next time. But we haven't found out with Chairman Wontumi. But again, that is his prerogative, and lawyers will always do this to try and tamper the things down. So just like the clarification has come in, a ceiling of 25 years, a minimum of 15 years. So at any chance, Chairman Wontumi, who was 49 at the time these offenses were filed, and who is 50 this year, we know that about 2-3 weeks ago, he celebrated his 50th birthday, could go for a minimum of 15 years, which will mean if he's to serve a full time in jail, he could be returning when he is 65 or 63 or less, or just a little less than that.
65.
And if the judge decides to go to 25 or 20, that takes him a lot in there. But we'll get to see how that goes and whether or not Chairman Wontumi,
I really want to see
for mitigation will happen.
His reaction to the sentence in court as it now. I can't wait for us to speak to our legal affairs correspondent. Fatal Bayaga is currently in the courtroom monitoring everything that is happening in the court.
Like you said,
right
yes,
now.
I've just seen the amendment. So what I was reading earlier on about the punishment was the 2006 law, which had just 3 and 5 years.
Right.
And then there was a consensus that was not punitive enough. And then section 99 says the person who buys or sells mineral without license or who mines without a valid authority granted under this act commits an offense and is liable on summary conviction to a fine of not less than 10,000 penalty units. One penalty unit is 12 cedis, and not more than 15,000 penalty units, and to a term of imprisonment of not less than 15 years and not more than 25 years. So the judge has a lot of option. He can impose a fine or impose custodial sentence or both. So he can impose part of a fine and impose custodial sentence in a part. We'll get to see